The smell of burning leaves had been part of autumn on my farm for as long as I could remember, but apparently that tradition was about to become a problem I never anticipated. I'm Aaron Anderson, and I've owned this 70-acre farm in rural Virginia for the past 15 years. My property sits on elevated land, just outside the planned community of Meadowbrook Estates, a development that sprung up about 8 years ago with their pristine lawns, matching mailboxes, and an HOA that seemed to have nothing better to do than create problems for everyone around them. The farm had been in operation long before any of those cookie-cutter houses existed, back when this area was still considered proper countryside rather than suburban sprawl. It was a crisp October morning when I noticed the silver sedan pulling up my long gravel driveway. I was out by the barn, preparing to burn the massive pile of leaves and agricultural waste I'd been collecting for weeks. This was standard practice, perfectly legal on agricultural property, and something I did twice a year without fail. The sedan parked near my house, and out stepped a woman in her mid-40s wearing a pantsuit that looked far too expensive for a casual farm visit. "Excuse me," she called out, her voice carrying that particular tone of authority that immediately set my teeth on edge. "Are you the property owner?" I wiped my hands on my jeans and walked over. "That would be me. Aaron Anderson. What can I help you with?" She extended a perfectly manicured hand, which I shook briefly. "I'm Patricia Pemberton, president of the Meadowbrook Estates Homeowners Association. I'm here to discuss a matter of significant concern to our community." I glanced at the pile of leaves I'd been about to ignite. "Let me guess. The burning," her expression tightened. "Yes, actually. We've been monitoring the smoke from your property for several seasons now, and it's becoming increasingly problematic for our residents. The smoke drifts into our neighborhood, affects air quality, and quite frankly, it's a nuisance that we can no longer tolerate." I crossed my arms. "This is a working farm, madam. Has been since 1987. I'm well within my rights to burn agricultural waste on my property. It's legal under Virginia state law for agricultural operations." Patricia's smile didn't reach her eyes. "I'm aware of the current laws, Mr. Anderson. However, we're prepared to take this matter to the county board. We have 300 homeowners in Meadowbrook Estates, and we all vote. That's considerable influence when it comes to local ordinances." "Are you threatening me?" "I'm informing you of reality," she replied coolly. "We're planning to petition for a burn ban in this area. With our numbers and political connections, I'm quite confident we'll succeed. I wanted to give you the courtesy of a heads-up before we proceed." I looked past her at the development visible in the distance below my property. The houses were arranged in neat rows, each with their emerald green lawns that somehow stayed perfect even during Virginia's hot, dry summers. It had always puzzled me how they maintained that level of green, given the area's water issues, but I'd never paid much attention to it. "You do what you need to do," I said finally. "But until there's an actual law preventing it, I'll continue managing my property as I see fit." Patricia's jaw tightened. "We'll see about that, Mr. Anderson. Good day." She drove off in a cloud of dust, and I stood there feeling the first stirrings of real annoyance. I'd been a good neighbor to Meadowbrook Estates since they'd built the place. I didn't run loud machinery at unreasonable hours, kept my livestock away from the property line, and generally minded my own business. But apparently, that wasn't enough for Patricia Pemberton and her HOA minions. I went ahead and burned the leaves that day. The smoke rose in gray plumes, drifting east toward the development. It was perfectly safe, controlled, and legal. But I knew this wasn't over. 2 weeks later, I received an official notice from the county. Patricia hadn't been bluffing. The HOA had indeed petitioned for a burn ban, and there was going to be a public hearing at the county administrative building. I read through the paperwork with growing frustration. They'd gathered signatures, compiled complaints about smoke, and even had documentation of supposed health impacts on their residents. I called my lawyer, an old friend named Tom Richardson who'd handled the farm's legal matters for years. They can't just ban agricultural burning because it inconveniences them, Tom said over the phone. But they can make noise, and if they get enough political pressure, the county might cave. You should attend this hearing and make your case. I plan to, I said. But Tom, this feels like harassment. I was here first, way before their development existed. Unfortunately, that doesn't always matter when you're one person against 300 voters. Politicians pay attention to numbers. But you've got rights too, and agricultural exemptions are pretty solid in Virginia. We'll fight this. The hearing was scheduled for early November, which gave me time to prepare. I pulled together documentation of my farm's history, proof of my agricultural operations, and research on Virginia's right to farm laws. But as I was organizing all this paperwork, something occurred to me that I hadn't thought about in years. I owned the water rights. It hit me while I was in my office, looking at the original property deed from when my grandfather bought this land back in the 1960s. The farm sat at the highest point in the area, and underneath, it ran an aquifer that fed several natural springs. My grandfather had purchased extensive water rights along with the property, which meant I controlled the groundwater for a significant radius around my farm. I pulled out more documents, tracing the history. When Meadowbrook Estates was being developed, the construction company had approached me about water access. This was back when I just inherited the farm from my father, and I'd been young and perhaps too accommodating. They'd asked to tap into the aquifer to supply irrigation for the development's common areas and landscaping. At the time, it seemed harmless. They offered to pay for the infrastructure to set up a pumping system that fed into their irrigation network, and I'd agreed to let them access the water for a nominal annual fee that I'd honestly forgotten about. I dug deeper into my files and found the agreement. There it was, signed 15 years ago, a contract granting Meadowbrook Estates water access from my property's aquifer for irrigation purposes. The fee was $200 per year, which they'd been paying automatically through some management company, so I'd never really paid attention to it. But here was the interesting part. The contract included a clause that allowed either party to terminate the agreement with 90 days written notice. I sat back in my chair, thinking. Those perfect green lawns I'd noticed didn't just happen naturally. The entire development was in a water management district that restricted residential outdoor water use during summer months. Virginia had been experiencing increasingly dry summers, and the county had implemented strict watering schedules for residential properties. But common area irrigation supplied by private water rights wouldn't fall under those same restrictions. Meadowbrook Estates' landscaping perfection depended on my water. I wasn't a vindictive person by nature, but Patricia Pemberton's threat had rankled me more than I wanted to admit. She'd basically promised to use political pressure to shut down a legitimate agricultural practice on my own land. The more I thought about it, the more I realized that maybe it was time to review all my business arrangements, including ones I'd forgotten about. The county hearing arrived on a cold November evening. The administrative building's meeting room was packed. I'd expected the HOA to show up in force, but I was still surprised to see at least 50 people from Meadowbrook Estates filling the chairs. Patricia sat in the front row, flanked by several other well-dressed residents who looked ready for battle. I sat on the opposite side with Tom beside me. We had our documents organized in neat folders, ready to present our case. The county supervisor, a tired-looking man named Gerald Hoffman, called the meeting to order. "We're here to discuss petition number 2020-118, a request to implement a burn ban affecting agricultural operations in the vicinity of Meadowbrook Estates. Miss Pemberton, you filed this petition. Please present your case." Patricia stood up, perfectly poised. She'd prepared a whole presentation, complete with a slideshow projected on the wall. Photos of smoke drifting over houses, charts about air quality, testimonials from residents complaining about respiratory issues and ruined outdoor events. "Ladies and gentlemen of the board," she began, "we're not here to attack anyone's livelihood. We understand that Mr. Anderson operates a farm. However, times change and communities evolve. What may have been acceptable practice 20 years ago is no longer appropriate when hundreds of families are living in close proximity. The smoke from these burns is not merely an inconvenience. It's a health hazard." She went on for 15 minutes, painting a picture of an inconsiderate farmer polluting the air while innocent families suffered. Several Meadowbrook residents stood up to give emotional testimonies about their children's asthma, their inability to enjoy their yards, and their property values being affected. Then it was my turn. Tom and I approached the podium with our materials. "Supervisors," Tom began, "what we're hearing tonight is an attempt by a residential development to retroactively change the rules for an established agricultural operation that predates their community by decades. Mr. Anderson's farm has been operating since 1987. Agricultural burning is a legal, EPA-approved method of managing organic waste. The smoke is temporary, occurring only a few times per year, and Mr. Anderson follows all proper safety protocols." I added my own testimony. "I've been a good neighbor to Meadowbrook Estates since day one. I've never complained about their lights, their noise, or the fact that their development changed the entire character of this area. But I've continued farming because that's what this land is for. Agricultural burning is part of that process. It's legal, it's safe, and it's my right under Virginia's right to farm laws." Tom continued, "Furthermore, imposing a burn ban specifically targeting agricultural operations would set a dangerous precedent. It would essentially allow residential developments to encroach on agricultural land, and then dictate how that agricultural land can be used. That's not how property rights work in Virginia." The board asked questions, looked at our documentation, and discussed the matter among themselves. The hearing lasted nearly 2 hours, with both sides presenting additional arguments and responding to concerns. Finally, Supervisor Hoffman spoke. "This is a complex issue that requires careful consideration. We're going to table this decision for 30 days while we consult with the county attorney about the legal implications of implementing such a ban. Mr. Anderson, during this time, we ask that you voluntarily refrain from burning if possible." "With respect, Supervisor," I said, "I have agricultural waste that needs to be managed. I can't just let it pile up indefinitely." He sighed. "We're not ordering you to stop. We're asking for cooperation while we sort this out." Patricia looked irritated that they hadn't immediately ruled in her favor, but she smiled tightly and nodded. "We appreciate the board taking this seriously." As people filed out of the meeting room, Patricia made a point of walking past me. "This isn't over, Mr. Anderson. One way or another, your burning days are finished." I watched her go, then turned to Tom. "Can they actually win this, legally?" "No, but politically, maybe. If enough pressure gets applied, the county might find some creative way to restrict you." We'll keep fighting, but I want you to be prepared for a long battle." I drove home that night thinking about water rights and leverage and how sometimes the best defense is a good offense. When I got back to the farm, I pulled out that old water access agreement again and read through every word carefully. The next morning, I called a water rights attorney in Richmond named Sandra Mills. She specialized in agricultural water law, and after I explained my situation, she was very interested. "Let me get this straight," she said. "You granted them irrigation access 15 years ago for $200 annually, and now they're trying to shut down your agricultural operations. That's the situation. And you want to know about terminating the agreement. I want to know my options." Sandra was quiet for a moment. "The contract is clear. 90 days written notice from either party terminates the agreement. You're well within your rights to do so. However, if their entire irrigation system depends on your water, this could get messy. They might try to claim they have some kind of easement or continued right of access. But they don't, right? It's a contract, not an easement." "Correct. A contract that can be terminated." They'd have to find alternative water sources, which in that area during summer restrictions would be difficult and expensive. "Aaron, I have to ask, are you considering this as leverage, or are you actually planning to cut off their water?" I thought about Patricia's threat, about her smug certainty that she could force me to change how I ran my own farm. "I'm considering it as a business decision. I'm reviewing all my arrangements and determining what makes sense going forward." "Fair enough. I can draft a proper termination notice if you decide to proceed, but my advice is to think carefully about this. It will make you very unpopular with that HOA. I think that ship has already sailed. Over the next week, I did something I should have done years ago. I thoroughly researched exactly how Meadowbrook Estates' landscaping operation worked. It turned out that their elaborate irrigation system, which covered all the common areas, the entrance landscaping, and several parks within the development, was entirely dependent on the water access I'd granted them. The development had been built during a time when water rights weren't as carefully scrutinized. The developers had gotten my permission to tap the aquifer, set up their pumping station on my property near the eastern boundary, and ran pipes throughout their community. According to my research, they used approximately 50,000 gallons per week during peak summer months just for irrigation. Without access to my water, they'd have to rely on county water supplies, which were metered and expensive. More importantly, the outdoor watering restrictions would apply, meaning their perfect lawns would be limited to watering twice per week during drought conditions. Those emerald green showpiece lawns would turn brown in a Virginia summer. I wasn't naive enough to think that cutting off their water wouldn't create blowback. But Patricia had made it clear that she intended to use every bit of leverage she had to shut down my farming operations. Maybe it was time to remind her that leverage works both ways. The county board met again in early December to discuss the burn ban proposal. I attended with Tom, and once again, the room was full of Meadowbrook residents. This time, they'd brought even more documentation, including air quality readings and a petition with over 200 signatures. Patricia had also gotten more aggressive. Supervisors, Mr. Anderson had 30 days to show good faith by refraining from burning. Instead, he conducted another burn just last week, showing complete disregard for this community's concerns. I conducted a controlled agricultural burn on my own property, which remains legal, I countered. I had crop waste that needed to be managed. I'm running a farm, not a spite campaign. The county attorney, a serious woman named Elizabeth Porter, had prepared a report. She stood to address the board. After reviewing the applicable laws, I have to advise that implementing a burn ban specifically targeting established agricultural operations would likely violate Virginia's Right to Farm Act. Mr. Anderson's property is properly zoned for agricultural use, and his burning practices comply with state environmental regulations. While I understand the concerns of Meadowbrook Estates residents, the county cannot simply prohibit legal agricultural activities because nearby residential developments find them inconvenient. Patricia's face went red. So we have no recourse. We just have to breathe smoke several times a year. You have the recourse of having purchased homes near an active farm, Elizabeth said bluntly. The farm was here first. Virginia law protects agricultural operations from nuisance lawsuits in exactly these situations. Supervisor Hoffman cleared his throat. Miss Porter's legal opinion is clear. However, I'd like to propose a compromise. Mr. Anderson, would you be willing to provide advance notice to the HOA before conducting burns? Perhaps give them 48 hours notice so residents can plan accordingly, close windows, that sort of thing. I considered it. That seemed reasonable enough. I can do that. I typically only burn 4 to 6 times per year anyway, and I always check wind conditions first to minimize smoke drift. That's not good enough, Patricia interjected. We want the burning stopped completely. And I want to be able to manage my property, I shot back. But we don't always get what we want. The supervisor banged his gavel. The compromise is my recommendation. Mr. Anderson will provide 48 hours notice before burning. The petition for a complete ban is denied based on the county attorney's legal opinion. This matter is closed. Patricia gathered her materials with sharp, angry movements. As the meeting adjourned, she stopped in front of me in the hallway. You think you've won? You've just made an enemy of 300 homeowners. We'll find another way. I haven't tried to make an enemy of anyone, I said calmly. I just want to be left alone to farm my land. We'll see how long that lasts. She stormed off, leaving me standing there with a cold feeling in my gut. Tom put a hand on my shoulder. You won this round fair and square. Don't let her get to you. But I was already thinking about that water contract sitting in my office drawer. Patricia had made her intentions clear. She wasn't going to drop this, and she'd keep finding ways to make my life difficult. Maybe it was time to make a business decision. That night, I called Sandra Mills again. I want to terminate the water access agreement with Meadowbrook Estates. You're sure about this? I'm sure. They're trying to destroy my farming operation. Why should I subsidize their landscaping for $200 a year while they're attacking me? All right. I'll draft the termination notice. Just be prepared for the fallout. I am. The notice was drafted, reviewed, and sent via certified mail 3 days later. The letter was straightforward. Pursuant to Section 7 of the Water Access Agreement dated March 2010, I was providing 90 days notice of termination. After 90 days, Meadowbrook Estates would no longer have access to the aquifer beneath my property for irrigation purposes. The pumping equipment on my land would need to be removed within that time frame. I sent copies to Patricia Pemberton as HOA president, to the Meadowbrook Estates Management Company, and to the development's original builder, though that company had long since moved on to other projects. Then I waited. It took 4 days for the reaction to come. My phone started ringing early on a Monday morning, a number I didn't recognize. I answered to find an angry male voice on the other end. Mr. Anderson, this is Robert Chen, property manager for Meadowbrook Estates. I just received your termination notice regarding our water access. This has to be some kind of mistake. No mistake. I'm exercising my contractual right to terminate the agreement. But you can't just cut off our water. Our entire irrigation system depends on that aquifer access. Do you have any idea what this will do to our landscaping? I imagine it will make it difficult to maintain, I said neutrally. But that's not really my problem. You have 90 days to find alternative arrangements. This is because of the burn ban petition, isn't it? This is retaliation. This is a business decision. I've been allowing you access to a valuable resource for pennies on the dollar. I've decided to terminate that arrangement. It's all perfectly legal. We'll fight this. We'll sue. You're welcome to try, but the contract is clear. Either party can terminate with proper notice. I've given proper notice. Robert hung up on me. 20 minutes later, Patricia Pemberton called. She was livid. What the hell do you think you're doing, managing my property and my business relationships, just like you suggested I should do? You're cutting off our irrigation water because you're mad about the burn ban. This is childish retaliation. Actually, Patricia, this is me realizing that I've been dramatically undercharging for access to a valuable resource. Water rights in Virginia are worth a lot more than $200 a year. If you'd like to renegotiate a new contract at fair market value, I'm open to discussions. Fair market value. You're trying to extort us. No. I'm correcting a 15-year-old mistake where I agreed to terms that were far too favorable to your development. But honestly, after your repeated threats and attacks on my farming operation, I'm not particularly motivated to help you out. You have 90 days. I suggest you start making alternative arrangements. You're going to regret this, Anderson. I promise you that. Is that another threat? Because I'm getting pretty tired of being threatened. She hung up without answering. Over the next week, I received multiple calls from various Meadowbrook representatives. Their management company tried to negotiate. Their lawyer called to threaten legal action. Several HOA board members called to plead their case. I remained polite but firm. The contract was being terminated. If they wanted to discuss a new agreement, we could talk, but the old sweetheart deal was over. What surprised me was the initial offer they came back with. Robert Chen called again, this time much more conciliatory. Mr. Anderson, we've discussed this with our board. We'd like to negotiate a new contract. We're prepared to offer $5,000 annually for continued water access. That's well below market rate for the amount of water you're using, I replied. I'd done my homework. Similar water rights in the area were leasing for $15,000 to $20,000 annually for that volume. But more importantly, I'm not interested in helping people who are actively trying to destroy my livelihood. What if we dropped all opposition to your agricultural burning? That got my attention. Go on. We withdraw any future petitions or complaints about your farm operations. We stop trying to interfere with your business. In exchange, you continue to provide irrigation water access. We're willing to pay $10,000 annually. I thought about it. $10,000 was closer to fair, though still on the low end. And having them officially back off would solve my immediate problem. But something about the whole situation still bothered me. Let me think about it, I said. I'll get back to you in a few days. I discussed it with Tom, who thought I should take the deal. You've made your point. They're backing down and offering decent money. That's a win. But when I talked to Sandra Mills, she had a different perspective. Aaron, I've been doing some research on Meadowbrook Estates. Their property values are heavily dependent on their aesthetic appeal. Those perfect lawns and landscaping are a major selling point. If their common areas turn brown and ugly, it affects everyone's home values. That's a lot of leverage. You could probably get them up to $15,000, maybe more. It's not really about the money, I said. Then what is it about? That was the question I'd been asking myself. What did I really want out of this situation? I'd been farming my land peacefully for 15 years before Patricia Pemberton decided I was a problem. I'd been a good neighbor, kept to myself, and never bothered anyone. Then they tried to use political pressure and threats to shut down my legal farming practices. "It's about respect," I said finally. "They treated me like I was nothing, like my property rights and my livelihood didn't matter. They thought they could just steamroll me because they have numbers. So you want an apology? I want them to understand that actions have consequences. You can't attack someone and then expect them to do you favors." Sandra was quiet for a moment. "Be careful, Aaron. Revenge can feel satisfying in the short term, but it usually costs more than it's worth in the long run. This isn't revenge, it's justice. Sometimes those look pretty similar." I told Robert Chen I'd consider their offer but needed more time. Meanwhile, winter set in properly, and the irrigation issue became less urgent. Meadowbrook's landscaping was dormant, and they wouldn't need heavy watering until spring. That gave them time to find alternatives, and it gave me time to think about what I really wanted. Christmas came and went. I spent it alone on the farm, as I usually did. I'd never married, never had kids, and most of my family had passed or moved away. The farm was my life, and that was fine by me. But the quiet holiday gave me time to reflect on the situation I'd created. Part of me wondered if I was being too harsh. Patricia Pemberton was a pain, no question, but was cutting off water to an entire development really the right response? On the other hand, they'd literally tried to ban my agricultural practices through political maneuvering. They'd made it clear they didn't care about my rights or my livelihood. In January, things escalated in a way I didn't expect. I was in town buying feed supplies when I ran into a woman I vaguely recognized from the county hearing. She was probably in her 30s, and she approached me cautiously in the parking lot. "Mr. Anderson, I'm Jennifer Morrison. I live in Meadowbrook Estates." I braced myself for another complaint. "What can I do for you?" I just wanted to say that not everyone in the development supports what Patricia is doing. A lot of us think this whole thing has gotten out of hand. The burn ban petition was ridiculous, and frankly, most people barely notice when you burn leaves. That surprised me. Really? Patricia has a small group of supporters who are very vocal, but they don't represent the whole community. Most of us moved here knowing there was a farm nearby. "We're not looking to cause problems." She hesitated. "I heard about the water situation. I understand why you're upset, but I hope you know that hurting the whole development to get back at Patricia means hurting a lot of families who had nothing to do with this." She wasn't wrong, and her words stuck with me. I'd been thinking of Meadowbrook Estates as a monolith, but it was really just 300 individual families, most of whom probably didn't care about my farming practices. "I appreciate you telling me that," I said. "For what it's worth, some of us are trying to vote Patricia out as HOA president. She's created a lot of problems beyond just this situation with you, but HOA politics are complicated." We talked for a few more minutes, and Jennifer gave me her contact information in case I wanted to discuss anything further. As I drove home, I felt my certainty wavering. Maybe I was being too rigid about this. Maybe there was a middle ground. But then, in early February, Patricia made sure to remind me exactly why I was angry in the first place. I received a citation from the county health department. Someone had filed a complaint alleging improper waste disposal on my farm. The inspector showed up unannounced on a Wednesday morning, wanting to examine my composting operations, my manure management, and my burning practices. I complied fully because I had nothing to hide. My farm was run according to all proper regulations. But the inspection took 4 hours and disrupted my entire day. At the end of it, the inspector found no violations, "Who filed the complaint?" I asked. He checked his paperwork. It was submitted anonymously through the county website, but it included detailed descriptions of your property and practices. Someone who's been watching you pretty closely. I had no doubt who was behind it. This was Patricia's new strategy. If she couldn't ban my burning through official channels, she'd try to harass me with complaints and inspections. 2 weeks later, I got another visit, this time from the county zoning office. Another anonymous complaint, this one alleging that I was running a business without proper commercial zoning. Again, the inspector found nothing wrong because my farm had been properly zoned agricultural since long before current regulations existed, with grandfathered status. Then came a complaint to the EPA about smoke violations. Then one to the fire marshal about unsafe burning practices. Each complaint triggered an inspection or investigation, and each one came up empty because I was running a legitimate legal operation. But each one cost me time, stress, and aggravation. After the fourth frivolous complaint in 6 weeks, I called Tom Richardson. "She's trying to bury me in bureaucracy. This is harassment." It probably is, but proving it is hard when the complaints are anonymous. However, if we can establish a pattern, we might be able to get a restraining order or file a harassment suit. "What I want," I said, feeling my patience finally snap completely, "is for this woman to leave me the hell alone." That evening I called Robert Chen at the Meadowbrook Management Company. "Your offer is rejected. The water agreement termination stands. You have 45 days left to remove your equipment from my property. Mr. Anderson, please reconsider. We can increase our offer." It's not about money anymore. Your HOA president has been filing false complaints against my farm for weeks, trying to shut me down through harassment. I'm done dealing with Meadowbrook Estates in any capacity. I don't know anything about complaints. "Then you should have a conversation with Patricia Pemberton. You have 45 days. I hung up feeling a grim satisfaction. Maybe this was petty. Maybe I was hurting innocent people along with the guilty ones. But I was tired of being attacked, and I was done being accommodating to people who showed me nothing but hostility. The reaction was immediate and explosive. Within 24 hours, I received a call from a lawyer representing Meadowbrook Estates, HOA. They were filing an emergency injunction to prevent me from terminating the water access, claiming that the development had established a prescriptive easement through long-term use. Sandra Mills laughed when I told her. "That's absurd. 15 years isn't long enough for a prescriptive easement, and they have a written contract that explicitly states it can be terminated. They have no case. But they can drag this out in court. They can try. It'll cost them a lot of money in legal fees and they'll lose. But yes, they can make noise." The injunction hearing was scheduled for early March. By this point, spring was approaching and the irrigation issue was becoming critical for Meadowbrook. Their landscaping crews would need to start watering within weeks, and without access to my aquifer, they were scrambling to find alternatives. I spent the weeks before the hearing documenting every anonymous complaint that had been filed against my farm. Tom Richardson hired a private investigator who traced the IP addresses used for several of the online complaints. They all came back to computers within Meadowbrook Estates, and 2 were traced to Patricia Pemberton's home address specifically. When the injunction hearing arrived, the courtroom was packed. Patricia was there with the HOA's lawyer, a sharp-dressed attorney named Marcus Webb. The HOA had brought several residents to testify about the importance of the irrigation system. Judge Catherine Morton presided. She was known for being no-nonsense and efficient, which I appreciated. Marcus Webb made his case. "Your Honor, Meadowbrook Estates has relied on this water access for 15 years. The entire development's landscaping infrastructure was built around this agreement. Terminating it now would cause irreparable harm to property values and the community's quality of life. We believe that long-term use has established rights that go beyond the original contract. Sandra stood to respond. Your Honor, this is a straightforward contract dispute. My client entered into an agreement that explicitly allowed either party to terminate with 90 days' notice. He has provided that notice. The HOA's claims about prescriptive easement are without merit under Virginia law. They're simply unhappy that a contract they benefited from is ending. The judge reviewed the contract documents. Miss Mills, this contract does appear to allow termination. Mr. Webb, on what basis are you claiming a prescriptive easement, long-term use, and reasonable reliance, Your Honor? The development was built with this water access as a fundamental component. But they had a contract that explicitly stated it could be terminated. That's not a prescriptive easement. That's a contract they should have renegotiated or bought out years ago if they wanted permanent rights. Judge Morton looked at me. Mr. Anderson, is there any particular reason you're terminating this agreement now? I stood. Yes, Your Honor. The HOA has been conducting a sustained campaign of harassment against my farm. Over the past 2 months, they've filed numerous false complaints with various county agencies, triggering repeated inspections that have disrupted my operations. Before that, they attempted to ban my legal agricultural practices through political pressure. I have documentation of all of this. Sandra submitted our evidence package. The judge spent several minutes reviewing it, her expression growing darker. Miss Pemberton, Judge Morton said, looking at Patricia. Are you the HOA president? Patricia stood. Yes, Your Honor. Did you file these complaints against Mr. Anderson's farm? I submitted legitimate concerns to the appropriate authorities. Concerns that were investigated and found to be baseless, multiple times. This looks like harassment, Miss Pemberton. Mr. Anderson's burning creates a nuisance for our entire community. We were trying to ensure he was following proper regulations. By filing anonymous complaints that you knew would trigger investigations, that's not civic engagement, that's harassment. The judge looked at both lawyers. Here's my ruling. The water access agreement allows termination by either party with proper notice. Mr. Anderson has provided that notice and has valid reasons for doing so, including documented harassment from the HOA. The injunction is denied. The termination stands. Marcus Webb stood. Your Honor, we'd like to request that the court order mediation between the parties. The court doesn't order mediation in contract terminations that are explicitly allowed by the contract itself. If Meadowbrook Estates wants continued water access, they can negotiate with Mr. Anderson in good faith. This hearing is adjourned. Patricia's face was crimson as we left the courtroom. She tried to approach me in the hallway, but Sandra stepped between us. My client has nothing to say to you, Miss Pemberton. All communications should go through me. This isn't over, Patricia hissed. Actually, it is, Sandra replied calmly. You have 30 days left before the water access terminates. I suggest you spend that time finding alternatives rather than making more threats. We walked away, leaving Patricia fuming behind us. Tom caught up with us outside. That went well, better than I expected, actually. The evidence of harassment helped, Sandra said. Judges don't like to see people abusing regulatory systems for personal vendettas. I felt relieved, but also strangely hollow. I'd won, but it didn't feel as satisfying as I'd thought it would. What happens now? Now they either find alternative water sources or they negotiate with you. But Aaron, the ball's in your court. You get to decide if you want to deal with them at all. Over the next week, I got several more calls from Meadowbrook representatives. Their management company offered $15,000 annually, then $20,000, then $25,000 plus an apology from the HOA board. I didn't respond to any of them immediately. Instead, I thought about Jennifer Morrison's words about innocent families caught in the middle. I thought about my own anger and whether holding on to it was serving any useful purpose. Finally, I called Sandra and Tom together for a conference call. I want to consider a new contract, but with conditions. What kind of conditions? Sandra asked. First, Patricia Pemberton has to resign as HOA president. Second, the HOA has to issue a formal written apology acknowledging their harassment. Third, they pay $30,000 annually for water access, with a clause that automatically terminates the contract if there are any further complaints, legal actions, or interference with my farm operations. And fourth, they pay my legal fees for all of this. Tom whistled. That's a tall order. It's take it or leave it. I'm not interested in ongoing conflict, but I'm also not going to be a doormat. Sandra sounded approving. I'll draft the proposal. Let's see what they say. I sent the proposal through Sandra's office the next day. Then I waited, half expecting them to reject it outright. 3 days later, Robert Chen called. We need to talk in person. Can you meet with myself and the HOA board? Patricia will not be present. That was interesting. Where and when? We arranged to meet at a neutral location, a conference room at a local bank. When I arrived with Tom, I found Robert along with 4 other people who introduced themselves as HOA board members. Patricia was notably absent. A woman named Helen Kramer, who appeared to be in her 50s, spoke first. Mr. Anderson, we owe you an apology. Patricia Pemberton acted without full board approval on many of the actions taken against you. When we learned the extent of the harassment campaign, we were horrified. Another board member, a man named David Torres, continued. Patricia has resigned as HOA president, effective immediately. We're conducting an internal review of everything that happened, and we're implementing new policies to prevent this kind of abuse in the future. We've reviewed your proposal, Helen said. We're prepared to accept all your terms. $30,000 annually for continued water access, automatic termination if there are any further issues, reimbursement of your legal fees, and a formal written apology from the HOA. I studied their faces, looking for signs of resentment or hidden agendas. They mostly looked tired and embarrassed. Why the change of heart? Robert answered. Honestly, we ran the numbers on alternative water sources. Between drilling new wells, upgrading to county water, and installing new infrastructure, we're looking at over $200,000 plus ongoing costs that would dramatically increase our HOA fees. Your price is actually quite fair for what we're getting. More importantly, several board members were planning to sue Patricia personally for her actions, which would have created a massive liability for the HOA. This was a disaster from every angle. Patricia became obsessed, Helen added quietly. The burn ban thing started as a legitimate concern from a few residents, but she turned it into a personal crusade. She didn't tell us she was filing all those complaints against your farm. When we found out, we were appalled. David spoke up. We're not asking you to forgive what happened. We're asking for a fresh start with new leadership and a clear understanding that we're neighbors, not enemies. I looked at Tom, who gave a small nod. These people seemed genuine and the terms were good. Most importantly, Patricia was gone, which removed the main source of toxicity. All right, I said. Let's draw up the contract. Over the next 2 weeks, Sandra and the HOA's lawyer worked out the details. The final contract was comprehensive, protecting both parties' interests while clearly establishing consequences for any future bad behavior. The HOA paid my legal fees, which totaled nearly $12,000. They also issued a formal apology that was distributed to all Meadowbrook residents, acknowledging the harassment and explaining the resolution. The contract was signed in late March, just days before the original termination deadline would have ended water access. I was now getting $30,000 annually instead of $200,000, and I had strong protections against future interference. But the story didn't quite end there. In early April, I received a visit from a sheriff's deputy. My heart sank, wondering what new complaint had been filed, but the deputy quickly put me at ease. "Mr. Anderson, I'm Deputy Williams. I'm here about Patricia Pemberton." "What about her?" "She's been arrested. Multiple charges including harassment, filing false police reports, and misuse of government resources. The county attorney's office has been investigating the complaints filed against your property." Miss Pemberton admitted during questioning that she filed most of them, knowing they were false, with the intent to cause you financial and operational harm. I sat down heavily on my porch steps. "She's actually being criminally charged." "Yes, sir. Apparently, yours wasn't the only situation." After she resigned from the HOA, other people came forward with complaints about her behavior. The DA decided there was enough for charges. "I need to get a statement from you about the impact of the false complaints." I gave my statement, detailing each investigation, the time lost, the stress caused, and the clear pattern of harassment. Deputy Williams took notes and assured me I'd be contacted if they needed further information. 2 weeks later, I got a call from the county attorney's office. Patricia had taken a plea deal. She pled guilty to filing false reports and harassment charges. Her sentence included probation, community service, fines, and mandatory counseling. She was also required to pay restitution to both me and the county for the cost of the investigations she'd triggered. The restitution check arrived in May, along with a court-ordered apology letter. Patricia's letter was brief and clearly written by her lawyer, but it acknowledged her actions and apologized for the harm caused. It felt like closure, even if it was forced closure. Spring turned to summer, and life on the farm returned to normal. The check from Meadowbrook Estates arrived on schedule, a reminder of how the situation had ultimately worked out in my favor. I conducted my agricultural burns as needed, providing the promised 48-hour notice to the HOA. Nobody complained. In June, Jennifer Morrison stopped by the farm with a basket of fresh baked goods and an invitation. "We're having a community picnic next month. Several of us thought it would be nice to invite you, kind of a peace offering and a fresh start." I was surprised but touched. "I'll think about it. I hope you come. A lot of people in Meadowbrook feel terrible about what happened. We'd like to show you that we're not all like Patricia." I did end up going to the picnic, feeling awkward and out of place in my farm clothes among the suburban families. But people were friendly, and many came over to introduce themselves and apologize for the conflict. Helen Kramer, the new HOA president, made a point of thanking me publicly for working out the water agreement. "Having a working farm nearby is actually one of the things that makes this area special," she said. "We should have appreciated that from the start instead of seeing it as a problem." Standing there with a paper plate of potato salad, surrounded by families and kids playing in the park, I felt something shift in my perspective. These weren't my enemies. They were just people trying to live their lives the same as me. Patricia had been the problem, not the development itself. As summer progressed, I found myself having occasional friendly interactions with Meadowbrook residents. I helped David Torres fix his riding mower when he stopped by asking for advice. I sold fresh eggs at a farm stand, and several families from the development became regular customers. Jennifer Morrison's teenage son started working part-time on the farm during summer break, wanting to learn about agriculture. The burns in fall went off without incident. I sent my notices, conducted the burn safely, and nobody complained. The smoke drifted over Meadowbrook Estates, just as it always had. But now it was understood as part of rural life rather than a personal attack. In October, exactly a year after Patricia first showed up at my farm, I was out preparing another leaf burn when a car pulled up the driveway. For a moment, my stomach clenched, expecting another confrontation. But it was Helen Kramer, and she was smiling. "Sorry to bother you," she said. "I wanted to drop off this year's water access payment in person, and to thank you again for being so reasonable about everything. I know we put you through hell." "Water under the bridge," I said, then laughed at my own unintentional pun. She handed me the check. "We also voted to name the main park in Meadowbrook after your grandfather, the Anderson Community Park. We found out he owned much of the land the development sits on back in the day. It seemed like a nice way to honor that history and acknowledge the connection between the farm and our community." I was genuinely moved. "That's really thoughtful, thank you." After she left, I stood looking at the check and thinking about how the situation had evolved. A year ago, I'd been angry and defensive, ready to fight to protect my way of life. I'd used the leverage I had, maybe more harshly than necessary, to make a point. But in the end, it had worked out better than expected. The farm was secure. I had a fair contract that protected my interests. Patricia faced consequences for her actions, and I'd gained something unexpected, a decent relationship with my neighbors. Life settled into a comfortable rhythm. The farm prospered, the checks from Meadowbrook arrived quarterly, and the burns continued without drama. I occasionally attended community events, no longer feeling like an outsider. The teenagers from the development started a program where they could earn school credit by volunteering on the farm, learning about agriculture and sustainability. 2 years after the initial conflict, I was invited to speak at a county land use planning meeting about balancing agricultural preservation with development. I talked about the importance of understanding and respecting established agricultural operations, about how communities can coexist if there's good faith communication, and about the mistakes that were made on all sides of the Meadowbrook situation. After my presentation, a man approached me. He was a developer planning a new residential community in a neighboring county. "I want to avoid the problems you faced. What advice would you give?" I thought about it. "Talk to existing property owners early and respectfully. Don't assume you can just overwhelm them with numbers. Understand that they have rights that predate your development, and be willing to compromise in ways that respect everyone's interests. Did you compromise too much? Give up anything you shouldn't have?" I agreed to give advance notice before burning. That's reasonable. Beyond that, I held my ground on what mattered. The key is knowing the difference between compromise and capitulation. As I drove home that evening, I reflected on everything that had happened. What started as a simple conflict over leaf burning had escalated into a battle over property rights, water access, and mutual respect. It could have ended much worse. If I'd been less strategic, if the HOA had been more reasonable from the start, or if Patricia hadn't pushed things to criminal harassment, the outcome might have been entirely different. But in the end, the system worked. The law protected my agricultural rights. The contract gave me leverage when I needed it. The courts enforced reasonable standards of behavior. And people, when freed from toxic leadership, proved capable of being decent neighbors. The farm is still here, still operating, still burning leaves twice a year when needed. Meadowbrook Estates is still there too, with their green lawns watered by my aquifer. The smoke still drifts over their houses on burn days, but now it's understood as the smell of a working farm, part of the character of living in a rural area that's slowly becoming suburban. I learned that sometimes standing your ground requires being willing to use every bit of leverage you have, even if it feels aggressive. But I also learned that winning the battle isn't the same as winning the war. Real victory came not from cutting off their water, but from reaching an agreement that worked for everyone while establishing clear boundaries and consequences. Patricia Pemberton taught me that some people will try to bulldoze you if they think they can get away with it. But she also inadvertently taught me that I had more power than I realized, both legally and practically. The farm that she saw as a nuisance turned out to control a resource her precious development depended on. That's a lesson in doing your homework before picking fights with your neighbors. 3 years later, I still occasionally see Patricia around town. She avoids eye contact and never speaks to me, which is fine. I heard she moved out of Meadowbrook Estates after the criminal case, too embarrassed to stay. Part of me feels bad about how everything turned out for her, but a larger part remembers the stress, the harassment, and the attacks on my livelihood. She made her choices, and choices have consequences. The farm continues to thrive. I've even expanded operations a bit, adding some new crops and a small farm store that's popular with both locals and Meadowbrook residents. The irony isn't lost on me that the same development that tried to shut me down now provides a significant customer base for my products. On cool autumn mornings, when I'm preparing to burn leaves and agricultural waste, I still feel a moment of tension. But then, I send my 48-hour notice to the HOA, prepare my fire breaks, check the wind conditions, and proceed with a clear conscience. The smoke rises, drifts east toward those perfect suburban lawns and dissipates into the Virginia sky. And nobody complains anymore, because they've learned what I always knew. This land was a farm long before it was anyone's backyard view, and it will be a farm long after. That's not stubbornness or spite. That's just reality, rooted in soil, law, and the kind of determination that comes from generations of working the same piece of earth. Some battles are worth fighting, especially when it's about preserving something that matters. But the best victories are the ones where everyone walks away with something, where the fight leads to understanding rather than just domination. That's what happened here, eventually, after all the anger and conflict and legal maneuvering. The water still flows, the crops still grow, and the leaves still burn. And in Meadowbrook Estates, the lawns stay green all summer long, fed by an aquifer beneath a farm that refused to be pushed around. That seems like a fair ending to a story that could have gone so much worse.